SJC-12261, David Wallace, v. PNC Bank.
Oh, yeah, it looks like.
Mr. Ludden, thank you for your patience. You may proceed.
Good afternoon, Mr. Chief Justice. May it please the court. I am Rockwell Ludden for the petitioner David Wallace. Given the long history and complexity of this case, I stand primarily on the briefs and appendices which I've submitted. If I may, I would like to touch upon 4 points which I think exemplify a pattern of abuse and error in the proceedings below. A pattern that most definitely affects adversely a number of substantial rights that Mr. Wallace had. That said, the first point is that the rules of claim and issue preclusion should have prevented the relitigation of the title issue in the second summary process action.
Was there anything that said, did the court say that it was with prejudice when they, was it with prejudice when it was dismissed?
No, it was not. The case was dismissed for lack of standing. However, Judge Merrick, who ruled in that case, did not make that determination initially. It came at the very end of a full hearing on the merits in which the issue of title was clearly determined by Judge Merrick. And under the rulings of this court, most recently, I believe, in the Abate versus Fremont case, it's made very clear that although ordinarily a dismissal without prejudice, or a dismissal based on standing, rather, operates without prejudice, that where the determination is made after the merits have been determined, that it operates with prejudice. I referred to that specifically in the brief. I don't know if you have further questions about that issue.
No, you can go ahead.
The second point is, this involves due process, procedural due process. And I think it is perhaps more clear to express it in the form of a question, which I do in the first person. Am I given the opportunity to be heard in a fair manner by an impartial tribunal when the judge in the case enters a decision based entirely on a fallacy of relevance? And what I mean by that is that the judge bases the decision not on the argument that I have presented, but rather substitutes in place of that argument a different argument that happens to be more easily dispelled based on existing precedent. This is also what happened in the second summary process action. The third point has to do with the chain of title at the Registry of Deeds. In this particular case, that chain of title contains a mortgage and it contains a foreclosure deed. There's nothing in between. There are no assignments. Now that worked well, or would have worked well, if the bank in this case had acquired the loan by succession and merger from the originating lender, which it claimed to have done throughout the first summary process action until it was revealed that this was in fact a misrepresentation. And I would like to say that my brother here was not counsel at that point, had nothing to do with that. But because of that, what came out in that first case, as a matter of fact, was that the bank was merely the servicer for the loan on behalf of a trust to which the loan had been transferred. It had been securitized well before the succession by merger took place. So what that means is that at the Registry of Deeds, there is nothing to connect the bank to that trust or that trust to the originating lender. In short, you have a flagrant violation of Ibanez and the Ibanez line of cases, which require an unbroken chain of assignment at the time of the foreclosure. There's another interesting issue here, and it involves some dicta in Judge Merrick's decision in the first summary process action, where he said that if the bank had shown that it was acting as an agent for the trust, that it would then have had the right to foreclose on behalf of the, I'm sorry, not the trust. What Judge Merrick said was that if the bank had acted as an agent for the holder of the mortgage, it would then have had the right to foreclose as the agent for that holder. Rather than simply owning up to the fact that it was a servicer in the first action, the bank instead chose to bring this second subsequent action, which again goes back to the res judicata issue. It could easily have raised that in the first action by way of an amendment or perhaps in some other form. But getting back to the other question, when you look at the Registry of Deeds, there is nothing to connect the bank, again, to the originating lender, basically, or to the trust. So Judge Merrick was correct, and it was never in dispute that if the bank were acting as an agent for the note holder, it could foreclose on behalf of that note holder. But that was never the argument made in the second action, which gets back to this fallacy of relevance. The argument that was actually made in that case was not that the bank did not have the right to foreclose on behalf of the trust. It was that the bank did not have the right to foreclose. It was rather that the trust itself did not have the right to foreclose. And the reason for that goes back to the fact that one of the idiosyncrasies of a securitization trust is that the trust property consists of mortgage loans, promissory notes, and mortgages, which continue to be governed by promissory notes and mortgages throughout the course of the securitization. That does not change. And when you look at the enforcement provisions of both the note and the mortgage, they very clearly place the right of enforcement with the holder, which is defined clearly in the note, and this is a banking industry creation, an adhesion contract, the language of which was created by the banking industry, and which very clearly states that the right of enforcement lies with the holder, and the holder is in turn defined with equal clarity as the owner of the beneficial interest in the loan, either the lender or one who takes by transfer and is entitled to the beneficial interest.
I have a quick question.
Yeah.
These are all issues that should have been brought forth at the appeals level, right? And that would have required paying the bond. So my question is, why not pay the bond and then go forward with the appeal as, you know?
Well, it's a good question, Your Honor, but it's easier said than done. In this particular case, the fourth point I was going to mention was that of jurisdiction. The court in the first case, the judge determined that there was no jurisdiction based on the bank's lack of standing. That lack of jurisdiction carried over into the second case. Why? Because the claim in the second case was identical to that in the first. It was a claim for possession. They tweaked the basis for their demand for possession somewhat, but it was essentially the same claim. And under the rules of preclusion, you can't try to recharacterize a claim simply by slightly reinventing the first claim. So what happened is, my argument and my response to your question is, without having first determined the issue of jurisdiction, where does a judge's right lie to impose a nearly $80,000 bond with ongoing use and occupancy payments, which effectively insulated his decision from further review, a decision that was clearly fraught with error, because, as I've said, it did not respond to the arguments that were actually presented to the judge, first of all, and secondly, it did not apply the rules of preclusion to the first. That decision in the first case was decided on the merits. That was, I hope, an answer to your question, that it would be patently unfair. The rules of preclusion are, claim preclusion, issue preclusion, are always circumscribed by the right to procedural due process. And they have to be applied even-handedly. Just in the past few months, I've had two summary process cases, two foreclosure-related cases, which were thrown out, dismissed on res judicata grounds because a pro se litigant had not raised a foreclosure challenge in the district court. So there's clearly precedent out there stating that the rules of preclusion apply.
Okay.
My question is, why were they not applied in this case to the benefit of the defendant rather than the plaintiff then using it?
All right.
So I think that's a serious constitutional issue.
All right, I'm afraid your time is up. Thank you.
Thank you very much. I appreciate your time.
Mr. Grant?
Good afternoon, Mr. Chief Justice, Associate Justices. My name is Mike Grant. I represent the appellee, PNC Bank, N.A. As a threshold matter, PNC's position is that this appeal is moot because this is an appeal from a summary process judgment, and Mr. Wallace, the appellant, has, along with the other appellants, have vacated the property immediately after the single justice denied the petition under 211, Section 3. So I'd rely on the cases cited in our brief for the proposition that this appeal is moot. Secondly, the single justice's decision should be affirmed because there was no abuse of discretion or clear error of law. The issue of rights of appeal and where you bring them is well settled, specifically with regard to summary process cases. Here, an appeal bond was entered first by the trial court, then affirmed by the appellate division after considering and rejecting the same jurisdictional, res judicata, and other arguments that the appellants assert here. At that point, the recourse was to suffer the dismissal of the appeal and then go to the appeals court on the limited appeal bond issue, which the appellants elected not to do. So the single justice properly exercised his discretion in denying the petition because it wasn't brought in the right manner. In fact, what the appellants are trying to do here is circumvent exactly why there is a statutory scheme with respect to appeal bonds, namely that prevailing plaintiffs in summary process cases are entitled to some protection to preserve judgments in summary process cases so that the ousted party doesn't get to free ride an appeal process to no end. So that's what's built in there, and the statute 239 section 5 says before any appeal is allowed, the bond has to be paid. So the legislature made very clear what the jurisdictional threshold is, and there's no dispute here that it wasn't satisfied. Lastly, I would just note that given all of the foregoing, as expounded upon in my brief, PNC has requested fees and costs under the statute as well as Rules of Appellate Procedure 25 and 26. And barring any further questions, I thank the panel and will rest on PNC's brief.
Thank you.
Thank you.
All right.